this on?
That one's on.
Okay. You can sit with us, Diane. There's a place in there. You can. It's up to you. However you'd like to do it. The only red. Good morning. Good morning to you all. My name is Susana SáCouto, and I direct the War Crimes Research Office. Thank you for joining us at this early morning hour. I want to extend to you a warm welcome to today's conference. It is a true pleasure to see you all here. The level of interest in this conference is a testament both to the many distinguished speakers we will hear from in the course of the day, as well as the importance of the issues we will be discussing. Before I offer a few opening remarks, I want to take a moment to thank all of our co-sponsors of this conference. In particular, the American Red Cross, the University of Oslo's Pluricourts Project, the American Society of International Law, and the American Bar Association's Rule of Law Initiative, all of whom have given of their time and logistical in-kind and financial support that have been critical to making this conference a success. The 2015-16 academic year marks the 20th anniversary of the WCRO. The office was established when our own Professor Diane Orentlicher, who was assisting then prosecutor of the International Criminal Tribunals for the former Yugoslavia and Rwanda, Richard Goldstone, with legal assistance, and created the office with the students who had been working with her at the time. Faced with bringing the first major prosecutions since Nuremberg and Tokyo, the ad hoc criminal tribunals found themselves at the forefront of international criminal law. The WCRO was created really as an outgrowth of the kind of specialized legal research and analysis that the prosecution of serious international crimes requires. The decades since then have seen an incredible number of advances in the field. Media executives have been held accountable for incitement to genocide. High state officials, including most recently the former Congolese Vice President Jean-Pierre Bemba, have been found guilty of crimes of sexual violence as both war crimes and crimes against humanity. And international tribunals have prosecuted and convicted heads of state challenging traditional notions of head of state immunity. For victims and people on the front lines, these advances have been painstaking. But if we look back, the milestones of these last 2 decades have been tremendous. At the same time, we've seen a perceptible shift in the field. The ad hoc tribunals created by the UN Security Council in the 90s to deal with the atrocities committed during the Balkans conflict and the Rwandan genocide have closed or will be closing shortly. Similarly, many of the so-called hybrid tribunals like the Special Court for Sierra Leone and the Khmer Rouge Tribunal, those being set up with international support in the countries where the atrocities occurred, have or are coming to the end of their mandate. Significantly in this scheme, we now have a permanent international criminal court. As a permanent institution, the ICC will obviously play a critical role in the developing architecture of international justice. But the ICC has significant limitations. First, the Rome Statute establishing the court does not yet enjoy universal jurisdiction, as our American citizens know well. Second, the ICC can only deal with crimes committed after the treaty establishing it came into force in 2002. Third, it has a potentially global mandate, which it must carry out with finite resources, meaning that it can only realistically handle a limited number of cases. So while the ICC will sometimes be the only option for holding certain perpetrators accountable, particularly where debilitated national institutions or an absence of political will makes domestic justice impossible, it cannot alone affect meaningful change in countries where atrocities have occurred. For the ICC to make a difference, it needs to be part of a broader set of accountability efforts. And that leads me to today's discussions. Although much has been accomplished in the last 20 years, we find ourselves facing a number of critical questions. How can the ICC and the international community more broadly effectively support accountability efforts beyond The Hague? What do we need for positive complementarity to work? What domestic or hybrid models have worked best? What lessons can we learn from external engagement in these models? What are, just as important, what are some of the cautionary tales? How can the ICC engagement with states be leveraged to improve domestic prosecutions of conflict-based sexual and gender-based violence, which until very recently, relatively recently, have been ignored or treated as secondary to other crimes? What are some of the unintended consequences of positive complementarity? And importantly, how do we ensure ongoing and constructive engagement between the various actors involved in the prosecution of serious crimes at the domestic level, including not just justice system actors, but donors and civil society groups? These are some of the questions we will be exploring today, and I very much look forward to the many insights that will no doubt emerge from our discussions. Before I turn the podium over to Dean Claudio Grossman, let me say a few very short words about the WCRO. In the past 20 years, we have worked with over 15 different courts, tribunals, and organizations involved in the investigation and prosecution of serious international crimes, both at the domestic and international level. With the participation of our faculty, students, staff, and expert consultants, many of whom are here with us today, the WCRO has not only undertaken more than 170 major research projects, but also launched several projects that have grown out of our work with the tribunals, such as the Gender and International Criminal Law Project, which we created in partnership with the Women in the Law program here, and which makes available online and free of charge a collection of searchable documents from 12 tribunals dealing with the prosecution of conflict-based sexual and gender violence. None of this would have been possible without the vision and dedication of Professor Diane Orentlicher, who served as the office's faculty director for the first 9 years of its operation, or the contributions of Professor Bob Goldman, who has served as its faculty director since 2004 and has been a tremendous source of support on both substantive and operational matters. Their mentorship and commitment to the office in the fields of ICL and IHL have been indispensable to the work of the office. I want to conclude with a heartfelt word of thanks to Dean Claudio Grossman, whose deep commitment and dedication to issues of human rights and human dignity have made him a steadfast supporter of our office. It's perhaps no coincidence that Claudio has been Dean of the Law School for as long as the WCRO has existed. We will miss him after he steps down this summer as Dean of the institution, which under his leadership has consistently earned distinction for international law programs. On a very final and practical note, the conference will be live streamed, and we invite you, as well as those viewing online, to help make this conference as interactive and dynamic as possible by tweeting with the hashtag WCRO at 20. And you can follow the WCRO on our new Twitter handle at War Crimes WCL. Thank you, and welcome again.
Thank you, Susana, for your opening remarks and for your tremendous and innovative leadership for WCRO since 2004. Things do not happen by chance, and they require steadfast commitment and passion with what we do, and you have embodied certainly the values of our institutions and done it with a tremendous commitment. We owe also much to Professor Diane Orentlicher, who directed this program till 2004 and founded it, and to my colleague, Professor Robert Goldman, who continued since that time until now. The strategic vision of this institution is very much reflected in this office and what it has accomplished has done. We were created by women, as a matter of fact, in 1896, when women were not allowed to study law or enter into the legal profession. And were brave people, and they were not brave retroactively when it is safe to be brave, but they were prospectively brave. When they founded this law school, they were ridiculized, laughed at, and people thought that they were altering the natural order of things. We get very nervous here when people blame nature for things that we all human beings construct. They established a very powerful tradition that we could see issues, identify issues, and we could roll our sleeves and work to solve them. And by the same token, following the tradition of our founding mothers, that the law has a tremendous role to play, because societal issues live in institutions, in norms, and appealing to the legitimacy that the law narrative gives provides a very powerful tool for the purposes of achieving social justice. We're not living in a world where international crimes, every international crime is punished, where the accountability reigns, but we're not going to give up and continue to work, imagining a reality where that's possible and thinking that our work can make a difference. This office contributions to international justice are an example of what is possible to do and give us a way to continue to build on. Their contributions are extensive, impactful, and unique. As Susana mentioned, the office started by supporting the work of the ad hoc tribunals of the former Yugoslavia and Rwanda. It has produced 19 different public reports on cutting-edge issues arising in practice and the jurisprudence of the International Criminal Court. The reports have been the source of discussion and debate and have contributed greatly to the strengthening of the rule of law. We in the Committee Against Torture, in the Inter-American Commission on Human Rights, they are quoted, cited, and seen as very important elements for decision making. So even beyond the strict group that works on the international tribunals, the impact has been transversal in the human rights community. And I will also say that over time, the office expanded its scope to include supporting domestic accountability efforts, which is the first line in this battle to achieve accountability. This includes filing an amicus brief in Guatemala, where sexual slavery and domestic slavery were prosecuted as international crimes in domestic courts, ultimately resulting in guilty verdicts of 2 former members of the military. The WCRO, in cooperation with our Women in the Law program, created the Gender Jurisprudence Collection, which is a unique resource that contains the gender jurisprudence of international, hybrid, and domestic courts. It has been instrumental in expanding accountability for conflict-based sexual violence in national, hybrid, and international courts. And I have seen the impact of this very important resource when I talk with the human rights activists from countries, different countries, particularly in the countries in development, where they don't have the resources to accede in a systematic way to this important jurisprudence. And what's matters when you can persuasively argue on with the jurisprudence that has an impact in judges and in policy makers. The 20th anniversary of WCRO's conference addresses the topic of prosecuting serious international crimes, exploring the intersection between international and domestic justice efforts. And gathered today, we have all of you, experts from all parts of society, academia, non-profit, diplomatic community, tribunals, and judiciary, the bar, government, and others. We look forward to an engaging discussion. I want to join also Susana in thanking the co-sponsors of today's event, ACEL, the American Red Cross, the pluricourts of the University of Oslo, and the ABA Rule of Law Initiative. Among our many distinguished speakers today is Justice Margaret McKeown of the Ninth Circuit of Appeals, who is the chair of ABA Raleigh and big promoter and defender of the rule of law. So we're honored and pleased that she's here. So please join me in welcoming her to the podium. Thank you.
Good morning. I'm pleased to be here on behalf of the American Bar Association Rule of Law Initiative, one of the co-sponsors of the conference. The topics today go to the heart of ABA Rowley's work. ABA Rowley began with the fall of the Soviet Union, a small number of lawyers and judges, then moving to the new republics to work with them on constitutions and other legal matters. But we've now expanded to programs in more than 50 countries. And our programs are quite wide-ranging. Some of them you'll hear about today, everything from gender justice to criminal justice to institution and capacity building. One of the important things, I think, is that our partnerships actually bring international law home. Dean Grossman spoke of the importance of domestic accountability, and in my view, the domestic courts are really the front line of international law, because it is there day in and day out that judges are using international law, both in terms of binding treaties and also in terms of adapting international law. For example, in my court, we have 3,000 Convention Against Torture cases every year. Now, day in and day out, courts are using international law, much of it without much acclaim. And what you read about, of course, are the high-profile cases. But I really urge you to think about what is done day in and day out, whether it's enforcing arbitral awards, whether it's Hague Convention and child custody, whether it's Convention Against Torture, or whether it's intellectual property. All of these represent bringing international law home. It's particularly fitting that we're here at American University and the Washington College of Law, and especially in the Claudio Grossman Conference Hall. We're pleased to have Dean Grossman as a member of our ABA Rowley board, and he and the law school have done so much to advance international law. I know there's a number of law students here, and I can say from watching the law over many decades that there are phases of popularity in law: civil rights, intellectual property, environmental law, and national security. But the interesting thing is that international law brings all of those together. So it's particularly important, I think, for students today to be studying international law. Of course, we have a number of challenges in today's world, and I think that your engagement here today represents an important step in trying to figure out how to make international law a reality, how to bring it from something that's not just a concept, it's not just a treaty in the books, but it's actually reality, and we know it affects people's lives day in and day out, as you'll hear today. So I salute Dean Grossman, American University College of Law here, and all of you, and ask you to celebrate international law. It's a wonderful thing, and I hope that you will be ambassadors, legal diplomats, for what is important. Thank you.
Good morning. It's my pleasure to add a final word of welcome and my duty to be very brief. This conference, as we know, brings together a global core of leading jurists, activists, and policymakers who dedicate their lives to making people safer from grievous harm through the protection of law. And its goal, the goal of this conference, is to mine our deepening experience in this endeavor to inform our work going forward. But as we've heard, and as you know, this gathering is also a celebration of an institutional milestone. And it's no coincidence that the program agenda in many ways reflects the journey of the War Crimes Research Office over the past 20 years. When the project was created, as Susana already indicated, there was an urgent need to ensure that the newly minted international criminal tribunals for the former Yugoslavia and Rwanda succeeded in their historic task. In that setting, and as Susana already alluded, two of my students, Brian Tiddamore and Rokas Kronk, who were aware that I was providing legal assistance to the first prosecutor of those tribunals, approached me and said they wanted to make a contribution too. They were deeply concerned about the atrocities that were still underway in Bosnia at that moment, and they asked if I would be willing to supervise a project called the War Crimes Research Office so that they could make that contribution. They assured me this project would only last 1 year. So I will always be so proud of their vision, their professionalism, and their contributions to the tribunal's jurisprudence in such historically important areas as gender-based violence, command responsibility, and so many other areas. And I'm thrilled that so many of the program's alumni are here today. But if I can be completely honest, I'm also very proud of myself because I made the stellar decision in 2004 to hire Susana SáCouto to lead the office as it embarked on its second decade. And to be honest, it's one of the best things I've ever done. I'm really proud of this. I'm also grateful to my brilliant colleague, Bob Goldman, who was willing to take over as faculty director when other commitments required me to step down from that role. Susana's leadership has exemplified core principles that so many of us have come to hold dear, and which Judge McKeown just mentioned. Well, the project has never lost sight of its role in strengthening international courts. Far from it. Its work is now deeply devoted to building and bolstering justice in the places where vulnerable people live. Just as important, the assistance the project provides, again under Susana's vision, isn't defined by the project's agenda. It's instead based on what clients tell Susana they need to make their work succeed under difficult circumstances, ranging from, as Susana indicated, training on effective fact-finding, investigative techniques, access to a user-friendly jurisprudence on prosecuting gender-based crimes, jurisprudence that reflects global norms, but also local norms, as well as providing the kind of complex, sophisticated legal analysis that the project has long undertaken on a superlative level. From Mexico to Afghanistan, from Argentina, Peru, and Guatemala to Bosnia, the project's provided local jurists and advocates and others a powerful assist behind the scenes, one of its strengths. Finally, Susana has always understood that work that is Herculean in scope, a word she has used in private conversations with me, that work has to be shared. And she's forged incredibly productive partnerships with others, notably including the co-sponsors of this event and many of the speakers on panelists today. So I want to really thank Susana for her brilliant leadership, wise vision, and profound impact. I'm getting choked up. And to congratulate her, Bob, and their mighty team on this wonderful 20th anniversary, and to wish you all a productive conference. Thank you.
Thank you. We are a few minutes behind, as we can see, so we're going to do a little change of speakers up here, and we will resume in about 2 minutes with our first panel, the Prosecutors panel, led and moderated by Stephen Rapp, our ambassador, former ambassador at large for global criminal justice. So thank you.
Welcome.
It's the green. I'm used to red. In any case, good morning, everyone. Welcome to this panel on making complementarity work. And as I was saying, I was thanking the good work of the War Crimes Research Office and how much it did for me and the offices that I led in the Rwanda Tribunal and at the Special Court for Sierra Leone, and how closely we worked together as well in support of international justice when I was at the State Department. But today, this particular panel deals with the issue of complementarity, an interesting word. I don't know if you have the same experience that I do, but every time I type it in a Microsoft Word document, it's highlighted, and over to the side it says no such word. And they're asking me to come up with use comparability or something else to that effect. But it is to some extent a concept that sort of runs counter to the way that we think about it. To define what we're talking about here, I think we're really suggesting what we can do to forward a preference in the world for robust prosecutions at the national level of Rome statute or crimes, of atrocity crimes. But the word, of course, refers to the ICC and to the fact that it is only complementary to national systems which have the primary jurisdiction for these crimes. But it doesn't define on how you can go about the process of making those primary actors effective. We have 4 speakers today. Our good friend Brenda Hollis had a conflict with her work in Sierra Leone, a hearing that she had to participate in today, so she's unable to be here. So we have 4 that should, we hope, give us more time for questions, and gives me a couple minutes perhaps to set the table in terms of how we might think that complementarity, particularly in the Rome Statute system, but also given broader global factors and interests and pressures, could work. And I think I view it and have come to view it in sort of 4 different ways. The first is what I call responsive complementarity. Now, I chose that adjective. I'm not sure if others have used the same term, and but it's fundamentally this aspect that, something pushed before Rome and at Rome and became an essential element of that Rome statute to some extent by implication, but that national actors would not want their political leaders, wouldn't want their military officers dragged off to The Hague. And so therefore, there would be this incentive, there would be a response to that global system by making robust national prosecutions possible. They would, and we see to some extent that factor operating in Colombia in the way in which it's defining the peace and framework with the FARC, so that, for instance, there can't be suspended sentences, even for fear that perhaps if there were, those cases would end up going to the Hague. This, however, requires the ICC to be, to some extent, a 900-pound gorilla. You fear it. You don't want your leader dragged off there, so you'll go ahead and do something in your national system. If it were a 90-pound weakling, you'd say, well, let's go ahead and take it on. Far better than creating a local special court that might prosecute more people, and we couldn't diss it as some kind of neo-colonial intervention. So that question of making that work is one part of it. The second is what's called positive complementarity, a term I think coined by Luis Moreno Ocampo, who not long after he coined it, the actors in the Assembly of States parties, the countries that pay the bills of the ICC, complained and said, hey, wait, we're not a development agency, Luis. There's plenty to do here in running these cases. Development actors can deal with those issues. And so the ICC, in terms of assistance to national systems, may help them on, say, drafting a Rome statute compliant local statute. But in terms of actually doing things locally, they're not, they don't have the resources. They're not given the resources to do that. And it's anticipated that that'll be by the development actors. And frankly, as our keynote speaker at lunch, David Tolbert, will tell us, those development actors are not actually so anxious to get involved in this area. We do have efforts represented certainly by the ABA Rowley programs, which received assistance from State Department bureaus for the mobile courts in the Congo, but that's really exceptional. Most development actors would rather get involved in health care or broader rule of law issues, and there's a salesmanship in development. You want to be able to sell your programs. So this is some of what we see with the World Bank now, perhaps diluting standards on human rights and workers' rights because they want to sell their aid. And one of the worst ways to sell the aid is say, hey, you need to prosecute your president. So, and efforts to sort of put donors together, which David led at Stockholm, in the end were rejected by the development partners. So how do we really make that work? Then there's what I would call cooperative complementarity, and that may run counter to the sort of legal contest that's implied here. But we see that in what the ICTY has done. That's why Yasmin's message today, I think, will be very important, is the ICTY, which of course had primary jurisdiction, and the locals had, sort of secondary jurisdiction, was mandated beginning in 2003 to transfer cases back and to work to prosecute cases at the local level. And that created a cooperative relationship. Is there a possibility that the ICC could do more of that? And the new CAR, Central African Republic Special Court, and the MOU that was signed between the government and the United Nations envisioned a cooperative relationship where the special penal court's investigators can work closely and share information with the ICC. So the ICC could prosecute 2 to 4 warlords, and the Special Penal Court could prosecute several dozen mid-level individuals. Is there a possibility that that system can work? And finally, in this issues upon which Siri and Claudia can focus, as we deal with cases that may not even fall within the Rome Statute, is how external actors can work effectively to ensure that there is justice somewhere, and ideally in the state where the crime was committed. And we see some of that dynamic in the way in which there was a Spanish case on Rios Montt, which may have had an effect upon Guatemala on Rios Montt. There was, of course, the prosecutor extradite case by Belgium in the ICJ that pushed Senegal, admittedly also an extraterritorial state, but closer to the scene of the crime, to proceed with Habre. So there are those sorts of factors. And then, of course, Claudia can talk about this remarkable institution, the Commission to End Impunity in Guatemala, CSIG, and the role that it played in capacitating efforts, perhaps not directly on atrocity crimes, but certainly with a profound indirect effect in making the national efforts there the success that they have been. So these are each, and of course I don't want to ignore, and we've got other actors here later, but the role of human rights groups, civil society groups, victims groups, external actors, internal actors are working together. And so I think this complementarity concept is to some extent how external actors can work through the ICC, through other institutions, to really make it more possible to have the will and the capacity to genuinely prosecute at the national level. So with the table set, let me turn to Anton Steynberg, who's, as everyone knows, is the senior trial attorney leading the Kenyan case against Ruto and Sang, who can respond in particular to these issues in regard to responsive complementarity and positive complementarity from the point of view of the International Criminal Court. Anton?
Very much, Stephen. Can you hear me? Doesn't seem to be working. Hello? Yeah. All right. A bit closer, I think. Before I start, a couple of disclaimers. I think many of you will be familiar with the structure of the ICC, but for those who aren't, the ICC is comprised of 3 independent organs: the judiciary, the Office of the Registry, and the Office of the Prosecutor. I am a senior trial lawyer in the Office of the Prosecutor, and I speak for the prosecutor here today. I do not speak for the judges, and I do not speak for the ICC as a whole. Second caveat, I am a trial lawyer. I'm used to speaking my mind. I'm not a diplomat. I'll try not to offend anyone, but I make no guarantees. Turning to the topic at hand, Stephen has prefaced a few of the issues I intend to discuss today. But I think perhaps a useful starting point is to try and define what is our ultimate goal. What is our ultimate goal in complementarity? What is our ultimate goal in combating serious international crimes? The end goal, as I see it, is to have a world where there is no place to hide for perpetrators of serious international crimes. Like the pirates of old, these people are enemies of humanity, and there should be no corner of the world in which they can hide, in which they can escape the reach of the long arm of the law, as it were. Unfortunately, in international crimes, the long arm of the law can sometimes be rather short. And what we need to do is to work to find a structure to lengthen that reach of law so that people cannot, to close the impunity gap. So the ideal would be to have a comprehensive, universal and integrated system of law, of justice that leaves nowhere to hide for these perpetrators. How do we go about this? Easier said than done, obviously. From an OTP perspective, the ideal starting point, of course, would be for the universal adoption of the Rome Statute. This would give us a common framework to tackle serious international crimes wherever they might occur. It would create an obligation on all countries that have signed up to the statute to criminalize serious international crimes which occurred in their jurisdictions and to prosecute such crimes when they occur. If they are unable or unwilling to do so, it would enable the ICC to intervene and to investigate and prosecute such crimes on their behalf, as it were. It would also provide a framework for cooperation between the court and the relevant state parties, a framework which actually obliges countries to provide the necessary assistance as regards investigation, arrest, and enforcement of sentences. It would also, of course, improve the funding of the ICC and extend the logistical reach of the court. Every year at the ASP, we are fighting for sufficient funds to fund the existing cases and to create a bit of a contingency for cases that might arise in the year to come. And every year we fall just that little bit short. So obviously, if we could extend the pool of donor countries, that might assist us in properly funding the court. Recognizing, however, that this ideal might not be achieved anytime soon, if at all, what other practical ways can we look at to enable domestic jurisdictions to contribute to the fight against impunity? Since the ICC has neither the jurisdiction nor the resources to tackle all serious international crimes on its own, it is then vital that domestic jurisdictions around the world have the legal tools, the capacity, and the political will to play their part in combating impunity. As a first step, a more realistic goal might be to at least ensure that all domestic jurisdictions adopt specific legislation criminalizing serious international crimes, so that they can also share the burden of prosecuting perpetrators over whom they may have jurisdiction. Turn to the issue of jurisdiction in a moment. Most countries, of course, will have offenses on their statutes, on their statute books with which persons responsible for serious international crimes could be prosecuted. So, for instance, a military leader who orders the deliberate or indiscriminate bombardment of a civilian population might be charged with murder in most countries. However, that does not properly acknowledge, in my view, the gravity of the offense as a crime against humanity. Other offenses, such as forced displacement, may not be recognized as crimes at all in many domestic jurisdictions. Similarly, many jurisdictions may not permit prosecution of military or civilian leaders on the basis of command responsibility for their failure to prevent or repress the commission of crimes by their subordinates. Additionally, the absence of serious international crimes on the statute books can hamper cooperation. In many countries, cooperation is limited to cooperation in investigations into crimes that are recognized in domestic law of that country. If you don't have those statutes on your law books, it may not enable you to provide the cooperation or to request the cooperation. For all these reasons and others too numerous to enumerate, it is vital to push for the specific criminalization of war crimes, crimes against humanity, and genocide in the domestic statutes and domestic statute books of all countries around the world. On the issue of jurisdiction, it's also important to extend the reach of the domestic laws as far as possible. Not necessarily to the extent of universal jurisdictions, which some flirted with differing degrees of success, but at least to extend jurisdiction to perpetrators who find their ways onto the territory of the country, even where the crime may have been committed somewhere else. Sort of extended jurisdiction would go a long way to closing the impunity gap and narrowing down the places where. Of course, by their nature, serious international crimes involve the commission of multiple crimes by multiple offenders, often over a protracted period. And as prefaced before, even where we have jurisdiction, our resources at the ICC are simply too limited to prosecute everyone. Our policy, therefore, is to focus on those who are most responsible, people at the top of the command structures, etc. And in order to avoid impunity, the OTP therefore encourages relevant domestic jurisdictions to deal with mid to lower level perpetrators, spread the net of accountability as far as possible, widely as possible. How do we do this? Well, apart from the prosecutors' diplomatic efforts in persuading countries to do what we believe is their moral duty to do, the OTP also engages in what, as Stephen has mentioned before, is termed positive complementarity. As a working definition, we can say that positive complementarity is the proactive or a proactive policy of cooperation aimed at promoting national proceedings. Which brings you to my next point. So firstly, the first point was the criminalizing of international crimes. The second point is to ensure that domestic jurisdictions have the capacity to investigate and prosecute serious and complex international crimes, particularly jurisdictions where legal infrastructures may be weak, either due to developmental issues or due to the aftermath of internal conflicts or wars. In this regard, the ICC can play a role by sharing its knowledge, experience, and expertise in the field. We can also cooperate with domestic jurisdictions by sharing information and evidence in our possession to the extent possible without endangering victims and witnesses. An example of positive complementarity is the prosecution of the leadership of the FDLR, a Rwandan militia group that occupied the eastern DRC after the genocide. And in this case, the OTP had a very successful cooperation with the French and German authorities to arrest and surrender, in the case of the French, one of the suspects to the court, and to prosecute domestically two of the other suspects in Germany who were recently convicted. The one surrender to the ICC didn't go so well, but about that later. We also cooperated with the DRC authorities to help them prosecute domestically the perpetrators, particularly of sexual violence, such as the mass rapes in Luvungi. And a number of persons were arrested and prosecuted in that. Another example is the Uganda situation, where the OTP has recently shared a large amount of evidence and internal work product with the Ugandan authorities, such as our expert analysis of LRA command structures, crime pattern analysis, transcripts, translation, and analysis of intercepts, radio communication logbooks, etc., to help them in their prosecution of LRA. I can give more details on the DRC example, perhaps in question time if there's an interest, but doing that now. So, of course, there are limits to what the OTP can do as far as positive complementarity is concerned. As Stephen has already prefaced, the ASP has made it clear that they're not prepared to fund training programs for domestic authorities. And this is where we need like-minded, state parties, like-minded non-state parties, such as, I hope, the US, and NGOs and civil society to play their role in helping to fund and build capacity. But in particular, in countries where such crimes have recently been committed. Many are indeed doing great work in that field. All right, I need to sit a bit closer. Many are doing great work in this field, but there's obviously a need for more to be done. And as Stephen's already noted, there are hurdles to be overcome, and we need to work together to try and clear those hurdles. Even in jurisdictions with well-developed justice systems, however, improvements can be made. And in this regard, I would like to stress the importance of having specialized investigative and prosecutorial units dedicated to the investigation and prosecution of serious international crimes. I can't overemphasize the importance of this. These cases are invariably complex and difficult to investigate and prosecute. Same investigators and prosecutors if the same investigators and prosecutors are also responsible for day-to-day domestic prosecutions, serious international crimes will invariably be relegated to the back burners and little, if any, progress will be made. Additionally, the creation of specialized units facilitates the development and maintenance of expertise in the investigation and prosecution of these sort of cases. In fact, the establishment, advancement and promotion of specialized units is one of the key measures identified by the EU Genocide Network in their 2014 report. All such units are expensive to maintain and may show little return on investment, often for years on end, which makes it difficult to justify their continued existence, particularly in this era of setbacks and austerity. Which brings me then to the third point, and that is that we need to take steps to ensure the necessary political will, that the necessary political will exists to prosecute serious international crimes domestically, including funding of specialized units. Without political will, no amount of capacity building will lead to genuine and effective national proceedings. These cases are invariably politically charged, and the sad reality is that many governments are more interested in securing financial or geopolitical advantage from a situation rather than ensuring that justice is done. This means that we need to ensure the strengthening of the rule of law in domestic jurisdictions. It means strengthening justice institutions so that prosecutors have the independence and courage to prosecute cases that may be politically inconvenient. In this regard, civil society can play a vital role in acting as the collective conscience of our political leaders. And I'll return to a recent example in my country, South Africa, in a moment. Those of us working in the field, however, can also play our role, and we need to speak out in defense of our colleagues when they come under fire for trying to do their job. The OTP has a role to play, particularly with respect of state parties, through the potential exercise of its propria motu powers of prosecution, where relevant authorities are reluctant to undertake a genuine and comprehensive investigation of the crimes concerned. And this is what Stephen referred to as responsive complementarity. It might also be colloquially described as big brother complementarity, although I don't think that term will probably catch on. Or 900 pound gorilla complementarity, I like that one even better. So this leverages on the reluctance of many state parties to have the ICC intervene in their domestic affairs and prosecute members of their government or armed forces for a variety of reasons, notably political embarrassment, probably be at the top of the pyramid. Thus, by opening a preliminary examination and monitoring the progress or absence of progress of national proceedings, the OTP encourages domestic authorities to undertake genuine and effective prosecutions of those responsible, all of those responsible, or risk the prosecutor exercising her proprio motu powers to intervene and do so herself. There are a number of examples where this has worked well. Stephen has already mentioned the situation of Colombia, where the prosecutor opened a preliminary examination 8 or 10 years ago now. And the government has taken significant steps to investigate and prosecute crimes. However, the initial investigations and prosecutions didn't reach what the prosecutor believed to be the highest levels of those responsible, including some of the generals responsible for the so-called false positive cases. Through this cooperative complementarity, a number of persons were in fact indicted. The prosecutor was also able to indicate in advance of any deals being struck with the FARC leaders that she would not regard any deal which provided blanket amnesty or suspended sentences to perpetrators as amounting to a genuine or reflecting a genuine will to prosecute those and punish those responsible, which led to some difficult decisions to be taken by the Colombians, and to their credit, although there are some that still criticize the results, to their credit, they've put together a investigation, prosecution, and system which the prosecutors at this stage satisfied meets the criteria set out in the Rome Statute. Another example is the case of Guinea, where the prosecutor opened a preliminary examination and has been following the investigations, and a number of high-level persons, including ministers, have been prosecuted. My time is running out, so I'll skip forward to the last point. And that is to stress the importance of international cooperation in the fight against impunity. From the ICC perspective, this means securing cooperation from non-state parties, and better cooperation from state parties as well. Again, state parties and like-minded non-state parties can play their role in lending diplomatic weight to secure better cooperation. Because when under the Rome Statute, when a state party doesn't cooperate, the only sanction we have is to refer them to the Assembly of State Parties. It is up to the fellow members of the Rome Statute to then apply the necessary pressure to ensure cooperation. Although we have secured cooperation in many cases, other cases cooperation has not been so good. And my case, the Kenya case, is a case in point. In the sister case against Kenyatta, the trial chamber has already made a finding of non-cooperation against the Kenyan government, and a decision pending whether or not it will refer the matter to ASP. Finally, I'd just like to refer to, well, final failure I'd like to refer to is the issue of the failure of the South African government to arrest Omar al-Bashir recently during the AU conference. And in this regard, the salutary efforts of the South African Litigation Center to force the government of South Africa to fulfill these obligations is to be commended. We need more interventions like this from civil society to act as the conscience of. In conclusion then, to get complementarity to work, we need universal criminalization of serious international crimes. We need to ensure that domestic jurisdictions around the world have both the capacity and political will to prosecute these offenses. And we need to ensure that domestic jurisdictions and international courts like the ICC cooperate effectively in the fight. Thank you for your attention.
Thank you for that very comprehensive overview of the way complementarity works and can work in the Rome Statute system. At this point, slightly out of order of our program in the agenda, I wanted to turn to Jasmine Mesic, who is the prosecutor of the Una Santa Canton in Bosnia-Herzegovina. And particularly because here we're talking about a situation where an international tribunal, the International Tribunal for the former Yugoslavia, has jurisdiction. And I think later today we have former Judge Patty Whalen, who served in Bosnia as an international judge in the War Crimes Chamber of the Bosnian State Court. to which cases were referred back by the ICTY prosecutor, in which there was a relationship between the ICTY prosecutor and the prosecutor in Sarajevo. But there's also another level in this process recognized in the war crimes strategy that was adopted now 5 or 6 years ago, which of course envisions as well that cases are going to be brought at the primary level, at the cantonal level in the federation, in the federation of Bosnian, Croatian, and Muslim populations, and in the district courts of the entity of Republika Srpska, and to speak to how that's working and how it could work perhaps better, and the kind of lessons that teaches us about this broader issue of making complementarity work between the international and national level. We'll turn to Jasmine Mesic. He's going to be speaking in Bosnian, but we will be have interpretation, I think, over the shoulder by Bohan Maranovic. So if we can yield to our second speaker. Welcome today.
Prije svega, ja bih da se zahvalim organizatoru na pozivu na ovu konferenciju i želim da kažem da vrlo cijenimo rad gospođe Susane i njenog tima.
I would like to thank the organizers of this event, and I would like to say that we value a lot the work by Ms. Susana and her team.
Mogu reći da nema dijela Bosne i Hercegovine koji nije upoznat s radom sa uredom gospođe Susan i vrlo je vrijedno ono što ona radi i uporednu praksu koju ona prikuplja sa međunarodnih i nacionalnih tribunala koji procesuiraju predmete ratnih zločina.
There's not a part of Bosnia that's not familiar with her work and that does not use her work in their practice.
Obzirom na vaš značaj, ja očekujem da ćete još dugo godina slaviti godišnjice vašeg rada.
We hope that you will continue your work for many years to come.
Ja ću ukratko prikazati vam situaciju procesuiranja ratnih zločina u Bosni i Hercegovini od početka rata pa do danas.
I will give a brief picture of prosecuting war crimes in Bosnia from the beginning of the war to today.
Bosna i Hercegovina je zemlja koja se nalazi na središtu Zapadnog Balkana, jugoistočne Evrope. Ista je bila u sastavu nekadašnje Jugoslavije, a po popisu stanovništva iz 1991. godine imala je 4,37 miliona stanovnika.
Bosnia and Herzegovina is a country in the Western Balkans or Southeast Europe, which was once part of former Yugoslavia, and according to the 1991 census, it had a population of 4.37 million people.
Obzirom na tragičan rat koji se je desio u Bosni i Hercegovini u periodu od 1992. do 1995. godine, uslijed velikih stradanja i raseljavanja stanovništva, još uvijek ne postoje tačni podaci o broju stanovništva nakon što je rat završen, iako je vršen popis stanovništva u 2013. godini koji još uvijek nije stupio na snagu.
Due to the tragic war that occurred in Bosnia and Herzegovina from 92 to 95, and due to the large number of its victims and forced migration that occurred as a result, there's still not an accurate number of Bosnia's post-war population, even though a census was taken in 2013, but is yet to be formalized.
Procjenjuje se da je u sukobima poginulo između 150 i 250 hiljada ljudi, između kojih najviše civila, kada je došlo do velikog razaranja zemlje uz masovne migracije i raseljavanje ljudi.
It's estimated that the conflict claimed between 150,000 and 250,000 lives, mostly civilians, and also included a large amount of destruction of the country and forced migration of its people.
Neke procjene govore da je približno 1 milion ljudi otišlo u izbjeglištvo od svojih domova, da je uništeno 30% predratnih stambenih jedinica, a tehnička i društvena infrastruktura pretrpila je značajna razaranja.
Some estimates indicate that nearly 1 million people were forced from their homes and became refugees, that 35% of the homes were destroyed, and the technical and public infrastructure sustained the most destruction.
Procjene su međunarodnih organizacija u Bosni i Hercegovini da je u toku rata silovano oko 50.000 osoba.
International organizations have estimated that there were 50,000 victims of rape during the war in Bosnia and Herzegovina.
Armija Republike Bosne i Hercegovine bila je pod kontrolom centralnih vlasti u Sarajevu. Okay. Svi ovi podaci govore o težini zločina koji su se dešavali na ovom području.
All these statistics speak to the weight of the crimes that were committed in this part of the world.
Obim zločina počinjen na teritoriji bivše Jugoslavije bio je takav da je 25. maja 1993. godine Savjet bezbjednosti Ujedinjenih nacija jednoglasno zaključio da treba formirati Međunarodni krivični sud koji će suditi pojedincima za teška kršenja međunarodnog prava do kojeg je došlo na području bivše Jugoslavije od 1.1.1991. godine.
The severity of the crimes committed in former Yugoslavia was such that the UN Security Council unanimously concluded that it was necessary to form an international criminal court which will prosecute individuals for severe crimes of international law that occurred in former Yugoslavia from January 1, 1991.
Na osnovu ovoga domaći sudovi su imali uporednu nadležnost u procesuiranju ovih krivičnih dijela, ali Haški sud imao prvenstvo u postupanju na domaćim sudovima.
As a result, the local domestic courts had complementary jurisdiction in prosecuting these crimes, but the Hague court had priority over cases they decided to prosecute.
Domaći sudovi u Bosni i Hercegovini sa procesuiranjem ratnih zločina započeli su još u vrijeme sukoba i neposredno poslije sukoba.
Domestic courts in Bosnia began war crimes prosecution during the war and continued after the war.
Nažalost, Bosna i Hercegovina je u toku rata bila podijeljena po etničkom osnovu, tako da pored međunarodnih elemenata koji su bili uključeni na početku rata, postojale su i vojne jedinice unutar Bosne i Hercegovine koje su bile u međusobnom sukobu.
Unfortunately, Bosnia was divided along ethnic lines during the war, so in addition to international factors which were present from the start of the war, there were also military units within Bosnia that were taking part in an international conflict.
Armija Republike Bosne i Hercegovine bila je pod kontrolom centralnih vlasti u Sarajevu, dok je Vojska Republike Srpske i Hrvatsko vijeće odbrane pod kontrolom novoformiranih vlasti na području gdje su oni djelovali.
The army of Bosnia and Herzegovina was under the control of the central government in Sarajevo, while the army of the Republika Srpska and the Croatian defense forces were under the informal governments in parts of the country where they had control.
U sukobima u Bosni i Hercegovini na određenom dijelu teritorije učestvovali su jedinice Vojske Republike Srpske krajine, koje su djelovali sa teritorije Republike Hrvatske, a kada se uzme u obzir da je na sjeverozapadnom dijelu Bosne i Hercegovine došlo do formiranja autonomne pokrajine Zapadna Bosna, na čijem čelu je bio Fikret Abdić, pojavila se i četvrta oružana sila koja se uključila u sukobe.
The conflict also included military units of the army of Srpska Krajina, which were present in Croatia. Additionally, in northwest Bosnia, there was an autonomous region called Western Bosnia, headed by Fikret Abdić, which introduced a fourth military unit into the fighting.
Ja kao tužilac dolazim sa područja Bosne i Hercegovine iz grada Bihaća, koji je nekad bio zaštićena u zona UN nacija, gdje su se odvijali oružani sukobi između više uključenih strana.
I am a prosecutor from the city of Bihać, which was once a safe haven of the UN, but where conflict occurred between several different sides.
Osnivanje Haškog tribunala kao Međunarodnog krivičnog suda za bivšu Jugoslaviju trebalo je da bude sud koji će suditi visoko rangiranim političkim vojnim dužnosnicima koji su bili odgovorni za masovno kršenje međunarodnog humanitarnog prava, ali istovremeno da budu i upozorenje istima da prestanu sa takvim vojnim kampanjama koji su imali za posljedicu velike civilne žrtve kod ratnih zarobljenika i bespotrebnog uništavanja objekata koji nisu imali opravdan vojni cilj.
The formation of the Hague Tribunal as a war crimes tribunal for former Yugoslavia was to be the court that would prosecute high-ranking political and military personnel, which were responsible for massive violations of international human rights law, but also to be a warning to some to stop with such military campaigns, which resulted in large numbers of dead civilians, prisoners of war, destruction of property, and it had no excuse to be military targets.
Međutim, to nije bilo dovoljno, pa su zločini u toku rata u Bosni i Hercegovini nastavljali da se dešavaju, čak i najteži oblici kao što je genocid, koji se desio u julu mjesecu 1995. godine u Srebrenici.
However, this was not enough, so the perpetration of war crimes in Bosnia continued during the war, including those most severe crimes such as genocide, which occurred in July of 95 in Srebrenica.
Međutim, značaj ovog suda je nemjerljiv za razvoj međunarodnog običajnog prava i definisanje pravnih standarda koji su od velikog značaja bili za pravilnu primjenu međunarodnog prava u nacionalnim zakonodavstvima.
Nevertheless, the significance of this tribunal is invaluable due to its definition of legal standards, which provided significant legal precedent of international law to the national legal systems.
Problemi sa kojima se susretalo pravosuđe u Bosni i Hercegovini u toku rata i neposredno poslije rata bili su vezani prije svega u nacionalnu podijeljenost koja je postojala kod onih koji su radili na ovim predmetima, jer ne treba smetnuti suma da su policijski istražitelji koji su jučer bili u vojnim jedinicama zajedno sa licima koji su trebali sada da procesuiraju zbog počinjenih zločina, a što uvijek to nije bio slučaj.
The problems which the Bosnian legal system faced during the war and after the war were due to the ethnic division that existed among those which worked on these topics. For example, the police investigators would be only recently members of the civil military units alongside individuals which now they needed to prosecute for committed crimes, which as a result was not being done.
Rat u Bosni i Hercegovini završio se bez pobjednika. 14.12.1995. godine potpisan je opšti okvirni sporazum o miru u Bosni i Hercegovini, takozvani Dejtonski mirovni sporazum, koji je zaustavio rat i koji je uredio ustavnu strukturu Bosne i Hercegovine, koja je sastavljena iz dva entitete, Federacije Bosne i Hercegovine, Republike Srpske i distrikta Brčko.
The war in Bosnia concluded without a winner on December 14, 1995, when the general peace agreement was signed called the Dayton Peace Accord, which stopped the war and provided a structure for Bosnia and Herzegovina, which was now to be made up of two entities, the Federation of Bosnia and Herzegovina and Republika Srpska, and also included a district called Brčko district.
Pravosuđe u BiH organizovano je na 4 nivoa, i to na državnom gdje postoji sud i tužilaštvo Bosne i Hercegovine, entitetskom gdje unutar Federacije Bosne i Hercegovine postoji 10 kantonalnih tužilaštava i sudova, u Republici 5 sudova i tužilaštava, te sud tužilaštvo distrikta Brčko.
So the legal system in Bosnia is organized on 4 levels, including a federal level, which contains a court and prosecutor's office, and then also organized on the entity level among the two entities, which contains 10 cantonal courts and prosecutor offices in the Federation of Bosnia and Herzegovina, and 5 municipal courts and prosecutor offices in Republika Srpska, and 1 civil court in the prosecutor office in the Brčko district.
U Bosni i Hercegovini predmete ratnih zločina procesuiraju se u zavisnosti od složenosti predmeta koji su dodijeljeni na rad ovim pravosudnim institucijama.
In Bosnia and Herzegovina, cases of war crimes are prosecuted depending on the straightforwardness or simplicity of the case in all these legal systems.
Ova razuđenost pravosudnih tijela također jedno vrijeme otežavalo efikasno procesuiranje zločina, jer su predmeti bili raspoređeni na više mjesta, pa je znalo biti paralelni istraga, što je imalo za posljedicu da se isti svjedoci u istom događaju saslušavaju po više puta.
The complexity of the legal system itself at one point was hindering effective prosecution of war crimes, since the cases were present in several courts at the same time, so this resulted in parallel investigations, which resulted in instances of witnesses being questioned about the same event on multiple occasions.
Ova praksa je dovodila do zamora svjedoka koji su bili i ostali najvažnije dokazno sredstvo za procesuiranje ratnih zločina, obzirom na protek vremena kao i nedostatak materijalnih dokaza koji su uništeni u toku rata.
This practice led to the exhaustion of witnesses, which were the biggest tool of evidence for prosecuting such cases, due to the passage of time and lack of material evidence, which was destroyed during the war.
2003. godine u Bosni i Hercegovini donešen je set krivičnih zakona koji su praktično pratili strukturu pravosudnih tijela u Bosni i Hercegovini.
In 2003, Bosnia adopted a set of criminal laws, which basically paralleled the judicial structure in Bosnia and Herzegovina.
Poseban progres u procesuiranju predmeta ratnih zločina nastao je formiranjem suda i tužilaštva Bosne i Hercegovine, čiji je rad zaživio 2005. godine.
Significant progress in prosecuting war crimes cases occurred with the formation of the Court and Prosecutorial Office of Bosnia and Herzegovina, which began in 2005.
Ove pravosudne institucije su praktično bile embrion Međunarodnog krivičnog suda za bivšu Jugoslaviju, koji je bio transmisija svega onoga pozitivnog u procesuiranju predmeta ratnih zločina ostvareno na tom sudu.
The judicial institutions were basically a consequence or result of the International Criminal Tribunal for former Yugoslavia, which was a translation of all positive prosecution of war crimes.
Jedno vrijeme u radu ovih državnih institucija bili su angažirani i suci, strani i tužioci koji su imali određeno iskustvo radeći na ad hoc tribunalima.
At one point, these federal institutions included foreign judges and prosecutors, which had specific experience working in ad hoc tribunals.
Ove pozitivne stvari sa suda i tužilaštva Bosne i Hercegovine spuštene su prema nižim pravosudnim nivoima, tako da danas prema informacijama misije OSCE u Bosni i Hercegovini ova tijela mogu u potpunosti udovoljiti obavezama u pogledu procesuiranja predmeta ratnih zločina, kako u fazi istrage pred tužilaštvima, tako i u sudovima.
These positive notes for the Bosnia Court and Prosecutor's Office are delegated to lower courts, so that today, according to information of the OESC mission in Bosnia, these bodies are able to totally satisfy their responsibilities in the aspect of prosecuting cases of war crimes, including the phase of investigation with the Prosecutor's Office as well as the courts.
Problem velikog broja aktera koji učestvuju u procesuiranju ratnih zločina u cilju izbjegavanja vođenja paralelnih istraga i odgovora države za efikasnije rješavanje velikog broja predmeta koji se nalaze u radu pravosuđa, a koji su između ostalog vezani i za materijalno-tehničke pretpostavke koje je potrebno obezbijeti, donijele u decembru mjesecu 2008. godine državnu strategiju za procesuiranje predmeta ratnih zločina u Bosni i Hercegovini.
The problem of the large number of actors which took part in prosecuting war crimes and with the aim of avoiding parallel investigations and responsibilities of the state of official prosecution of a large number of cases that were in front of the courts, but which are among others connected to material and technical necessities that are yet to be obtained, led to the development of a state strategy for prosecuting war crimes in Bosnia and Herzegovina in 2008.
Ova strategija postavila ambiciozne ciljeve da se najsloženiji predmeti riješe u roku od 7 godina, dok manje složeni predmet u roku od 15 godina od dana njene donošenja.
This strategy laid out ambitious goals so that the least straightforward or simple cases are solved within 7 years, while the more straightforward or simple cases are solved within 15 years.
Iako su uloženi veliki napori, strateške mjere od 7 godina nije izvršena jer još uvijek postoji velik broj predmeta na kojima se radi.
Even though the significant effort has been made, the strategic goal of 7 years has not been met since there are still far too many outstanding cases.
Učešće i pomoć međunarodne zajednice u radu na ovim predmetima u Bosni i Hercegovini je od iznimne važnosti. To se prije svega odnosi na materijalnu i financijsku pomoć, kao i edukacijsku, sudsko-tužilačku i policijskih kadrova koji rade neposredno na ovim predmetima.
Assistance in the international community in these cases of Bosnia and Herzegovina is of utmost importance, which more specifically centers on material and financial assistance, as well as education of judicial, prosecutorial, and policing institutions, which simultaneously work on these cases.
Značajan problem u procesuiranju predmeta ratnih zločina ogleda se u nedovoljnoj podršci i zaštiti svjedocima koji su osnovno dokazno sredstvo ovim predmetima.
The significant problem prosecution faces in war crimes cases relates to inadequate protection and support of witnesses, which should provide the fundamental evidence in such cases.
U Bosni i Hercegovini pravosudni organi u procesuiranju predmeta ratnih zločina primjenjuju u zavisnosti od vrste krivičnog djela 2 krivična zakona, i to krivični zakon BiH iz 2003. godine, koji propisuje krivična djela genocida, zločina protiv čovječnosti, ratnih zločina, te krivični zakon SFRJ iz 1976. godine koji je bio na snazi u vrijeme izvršenja krivičnih djela.
The judicial system in Bosnia uses 2 statutes of prosecuting war crimes, one being the criminal law of Bosnia in 2003, which defines the criminality of genocide, crimes against humanity, war crimes, and second, the criminal law of the Socialist Federal Republic of Yugoslavia from 1976, which was in effect at the time these crimes were committed.
Obzirom da entitetsko pravosuđe rade na manje složenim predmetima, ovaj zadnji zakon se primjenjuje u gotovo svim slučajevima.
Keeping in mind that the judicial system at the entity level deals usually with the more straightforward or simpler cases, the second law, 76 law, is usually used in most cases.
Ovaj zakon nije predviđao zločin protiv čovječnosti kao krivično djelo, ali isti propisan krivični zakon u Bosni i Hercegovini iz 2003. godine, gdje se isti primjenjuje na navedena djela, a iz razloga što je zločin protiv čovječnosti bio zabranjen prema međunarodnom običajnom pravu.
This law did not foresee a crime against humanity as a crime, but the same is defined from the criminal law Bosnia in 2003, which now used it in such cases, because the crime against humanity was forbidden according to international norms.
Od 2013. godine napravljen je značajan napredak u rješavanju predmeta ratnih zločina, jer isti je povezan s značajnom donacijom Evropske komisije kroz EP fondove, gdje je kao strateški cilj postavljeno da se u roku od 5 godina riješi 50% predmeta.
Since 2013, there have been significant progress in solving crimes or cases of war crimes, mainly due to a significant donation from the European Commission to IPA funds, where the strategic goal was defined as solving 50% of the cases within 5 years.
Dosadašnja implementacija pokazuje napretke u ovom procesu.
The implementation to today shows significant progress on this project.
Statistički podaci govore za 2015. godinu da traju postupci u 260 predmeta ratnih zločina i to da je 27 predmeta u fazi potvrđivanja optužnice, 71 predmet u predraspravnoj fazi, 31 predmet čeka početak suđenja, dok je 131 predmet u fazi suđenja.
Statistics show that for 2015 there were 260 open cases of war crimes. 27 of those are in the phase of confirming the accusations. 71 cases are in the phase of pre-trial phase. 31 cases are awaiting trial, and 131 cases are in the trial phase.
U periodu od 2004. do 2015. pravosnažno je okončano 380 predmeta.
In the period from 2004 to 2015, there were roughly 280 judicially concluded cases.
Ovi pozitivni trendovi ukazuju da pravosuđe Bosne i Hercegovine je na dobrom putu da u skladu sa svojim mogućnostima i s pomoć prijatelja iz međunarodne zajednice udovolji svom osnovnom cilju, a da to što veći broj osumnjičenih lica za ratne zločine izvede pred lice pravde, da se isti na način osigura vladavina prava i da satisfakcijama žrtava sve ono što su pretrpili u minulom ratu u Bosni i Hercegovini.
These positive trends show that the judicial system of Bosnia and Herzegovina is on the right track to, in conjunction with funds from the international community, achieve its basic purpose, which is to bring justice to the largest number of those accused of war crimes, and to, in such manner, ensure the rule of law and justice to victims for all that they endured in the recent conflict in Bosnia and Herzegovina.
Thank you.
Well, thank you very much, Jasmine, for that great presentation, and sorry to be rushing this, and we know that with the interpretation it cuts down on the length of the speech that's delivered, but I know that we hope we still have time for questions. There'll also be discussions in one of the concurrent panels by several of the actors regarding prosecutions at the national level in the former Yugoslavia. Let me turn now to Siri Freegard. We heard mentioned by Anton of the European network of war crimes prosecutors and genocide prosecutors, and Siri was very active in that movement as the Norwegian prosecutor. The EU network has the EU countries, but also 4 cooperative countries, including Norway, Switzerland, Canada, and the United States. And the idea of these sort of no safe haven prosecutions, prosecuting war criminals and other perpetrators of atrocity crime when they come to your country is something that, though as Anton said, is challenging to have political support for, but on the other hand, is something that one can build a coalition around, because it is an important way to both vindicate human rights and send a powerful message about countries being welcoming to those that are willing to observe the law and very strict with those that would commit the worst crimes known to humankind. Siri also was essentially the chief international prosecutor at the special panels in East Timor, and can also speak to that. So let's turn to Siri at this point. Thank you.
Thank you. And I'll try to keep it. You hear me? Okay. Let me start by saying that I am a prosecutor, not only by education, but also by heart. And I think that my most important task is to be able to start investigations, to finish investigation, to get enough evidence, to bring cases to court, and have the decision from the judge whether or not it's an acquittal or conviction. This is easy to say when it comes to ordinary crimes, the national crimes in your own country. It's more difficult when it comes to the international crimes. And I would like to give you also an example on challenges that were so strong that we did not manage to bring a case to court. That was in East Timor, and I will end with that. But let me start with the Norwegian system or the Norwegian way of dealing with international crimes. I will be a little bit short about it because Anton Steynberg, he gave the recipe for how to do it. And actually, I think we have followed every step he was giving. We established 2 units in 2005, one for prosecution and one for investigators. And the point with that was that we considered that it was too difficult for ordinary police to investigate these cases. They needed to be trained. They needed to learn how to tackle culture in other countries. So what we did was that we were sending all the investigators and most of the prosecutors to training in The Hague. And also, I have to say that one of the main assets in Norway was that we had a very strong political will at that time not to be a safe haven. The politicians were supporting us. They didn't want Norway to be a safe haven for war criminals. We also did, as Anton Steynberg was saying, we changed the law. We got new regulation to cover all the elements of that we needed to prosecute these crimes. And also we got universal jurisdiction, which means that we can prosecute foreigners having committed crimes abroad, even if they are abroad. And at one time, Norway, supported by the politicians, were willing to take over a case from Rwanda to prosecute, just to show the willingness we had. At this time, the atmosphere I think in Europe and in the Scandinavian countries was that we want not to be a safe haven. Denmark started with a unit of 16 persons, both prosecutors and investigators, and we followed up. So in a way, we were following up what Denmark did. I would like to say that even if we have the universal jurisdiction, we have never investigated a case where the alleged perpetrators were not in the country. And I have to say that even if we have this universal jurisdiction, we are not using it. Because the complaints that we have received against persons, foreigners being abroad, we have not opened investigation in those cases. And I will say, I'm a little bit careful to say political will, but at least there is no political willingness to give resources to be able to investigate those cases. Because in a way, everything comes down to certain words that Anton Steynberg was mentioning. Political will is necessary because you need the resources, and the resources you get if there is political will. You need cooperation, and cooperation is necessary because you can't do everything alone. Being a third country like Norway, to investigate those cases, we have to go abroad. The whole investigation is taking part in other countries. We need a cooperation from the country in question. We need a cooperation from the international tribunals because we need information from them and we need help from them. We need to be advised from them how, for example, to find certain persons, or also we need to get the statements that they can give and that is concerning the situation we are investigating. The atmosphere, as I said, in 2005 in Norway and in other Nordic countries was quite positive. Finland investigated one case from Rwanda. Denmark has investigated cases. Sweden have. We have investigated with success, I will say. 2 cases, one concerning Bosnia-Herzegovina and one concerning Rwanda. The problem is that these cases have taken time, 10 years altogether from we started investigation till both cases were closed. The first conviction we had in 2011 and the second conviction we had in January 2015. The atmosphere in today is slightly changed. We all know the problems in Europe with the asylum seekers coming from Syria. We know about the terrorist cases, the terrorists. And of course, it is important also to focus on terrorism. Norway is focusing quite much about the young Norwegian boys going to Syria and coming back after they have been warriors in Syria. So I will not again use the word political will, but I think I would say that the willingness from the top, not only the politician, but also the persons in charge of the financial situation and resources, are less open today than it was in 2005. Because we have seen what resources we needed to investigate the case from Rwanda, for example. More than 80 witnesses, more than 40 had to be brought to Norway to give their testimony, not only once, but twice, in the first court and also in the Court of Appeal. And also a difference between the third countries, as I call it, and the domestic country that has where the crime has been committed, is that in those countries you have still victims crying for justice. In the third country, people are more concerned about their own problems in their own country, the rapes, the burglary, and so on. So to the politicians, you don't have that pressure on them to give resources to investigate all these cases. Since 2015, we have not opened a new investigation. I'm not saying they are not doing anything, but still, we could have opened a new case, for example, about Rwanda, but there are some reluctance to do it. And that is because the resources are going other places. The investigators who was dealing with the crimes against humanity and the genocide are also now doing cases of terrorists. So in a way, we have to prioritize in another way that we did before. So for the prosecutors, it's very important to be proactive and to put pressure on the people who are deciding to be able to open new cases. And I think also that the international community should be a very good co-player in that, to be able to put more pressure on the different countries to not to forget the cases that goes, the cases about the serious crimes. Because the time is passing very quickly, I will just end by saying something about Rwanda. About East Timor. I have to skip all the details because of the time frame, but in Rwanda we were investigating the crimes against humanity that took place in 1999. In the beginning, the focus for the investigating and prosecution unit that was established by the UN was to focus on the small price. the people who were staying in the country and who was part of the militia and had been killing or raping or whatever. When I came in 2002, I decided to change that, and we started to investigate the high command, the people who had organized the killings, that organized the raping and the destroying of the country, and who was mainly Indonesian military, high command or police. After 1 year, we very successfully made indictments, many and quite a few indictments with many people indicted. Also, we started to investigate the one we thought was the main organizer of these crimes, a general called Wiranto, who had been prior he had been Minister of Minister Defense, sorry, in Indonesia. When we started this, I informed the representative of the UN in East Timor, and also I informed the general prosecutor at that time, who was a Timorese, and everybody agreed on it. When we finalized the indictment against Wiranto and 7 others during participating or in the high command of the military and police in Indonesia, I knew that the press would be very interested in it. So I went to the court and asked, because I had to file the indictment in the court to make it valid, and I asked them to keep it secret for 1 day so I could inform all the persons I knew would be asked by the press to comment on it. That was the president, 7 ministers, and also the UN's representative in East Timor. To my great surprise, the UN issued a statement saying that this indictment has nothing to do with the UN. It's a product of the East Timorese justice system. The president, who was in Malaysia, was not informed by his chief of staff when I gave the indictment to his office. So he was met by the press and said that, oh, this is positive. That was his first remark. Then this statement came from the UN. And the next day, the president had a press conference saying that this has nothing to do with us. The UN started it. The UN is responsible, and the UN has to finish it. To make it quite short, we felt quite alone in this, but we were sure that we had done what was correct. At a certain moment, I was asked to withdraw the indictment, which I said I cannot, and I will not do it either. I was approached by a representative from Indonesia saying, do you know what you have done? And I knew what I've done, so that was not a problem. But the point is, there was no will internationally to support the indictment. And after 1 year, and finally the court in East Timor, also a court with internationals, issued the arrest warrant, the general prosecutor said I will not send it to Interpol for red notice. Indonesia was not cooperating. And I was told orally that one of the reasons was that Indonesia was too important in the fight against terrorism. So nobody wanted to support it. Then the international community, the NGOs, started to react and wrote to the UN and put pressure on the UN. So UN changed their statement and came out with a new statement. Still a little bit vague, but at least it was some sort of a support. I'm saying this because this was a challenge that stopped us in prosecuting these people that we were sure were guilty. the challenge was too big. The international community was able to change a little bit. But I think this is important when it comes to the international community, that you have to put pressure on all governments and institutions to support that work. If not, we are all failing. I stop there.
Well, thank you very much for that sobering report. I would add just a small bit of news on the European network. The Dutch are the president of the EU during this 6-month period, and their justice minister, in cooperation with the EU justice minister, have announced that May 23rd will be a European Day Against Impunity to salute and encourage the work by the European network. So hopefully that's followed with resources and political support on cases. So as the French say, en verra. Okay. So let's, last but not least, and certainly not least, a heroine of all of ours, the former Attorney General of Guatemala, Claudia Paz. Everyone knows about the historic case against former Chief of State Efraim Rios Montt, and the verdict delivered in May of 2013 of genocide against him, though obviously the challenge in the judicial process remains. With Claudia yesterday celebrating as well the fact that her successor carrying on her work recently won convictions in the sexual violence case in Guatemala. But to describe how it was possible in Guatemala, facing these challenges of what many refer to as the sort of power of the deep state and its implication in the humanitarian violations, the genocide, the crimes against humanity, and war crimes, particularly committed in the 1980s. Let me turn now and let's all welcome Claudia Paz. Claudia?
Thank you so much for giving me the opportunity to share the experience of Guatemala, and congratulations for the anniversary. I think that this is the only pure national case, but as you said, the international aspect or external actors were not absent. In Guatemala, as some of you know, we suffer an internal armed conflict that lasts more than 3 decades, and ended with the signing of the peace agreements in 1996. We have a truth commission, and they concluded that more than 200,000 people were either killed or disappeared. And the commission also concluded that between 1991 and 1993, acts of genocide were carried out in certain areas of the country. For more than 10 years, the majority of these serious human rights violations have remained in impunity. But on the 10th of May, in 2013, we have a sentence saying that Efraim Rios Montt was guilty of genocide. This is the first sentence in a national court against a former head of state, saying that he was guilty for the crime of genocide. I think in Latin America, I don't know another one of these sentences in the world. The Constitutional Court of Guatemala overturned the sentence 10 days later. A new trial was ordered, and is today, and these days, this new trial is currently being developed with the difficulties that to which I will refer in a few minutes. But before addressing these difficulties and the challenges for the future, I would like to address 2 questions that I consider very important. The first one is, which condition facilitate that these another trials for serious human rights violations could be carried out in the national court. And the second one, what was the legacy of the trial for the Guatemalan system, for the Guatemalan society, for the victims? Regarding the first question, I feel that the fundamental condition for this process to be carried out was the demand of the victims and the survivors of the genocide, who for more than 30 years did not waver their efforts to achieve justice. For a long time, in very advanced conditions, the survivors found ways to make their voices heard. Even the power of the perpetrators who were present inside their communities as former civil patrols or former military commissioners, and having to appeal to a justice system that for decades was dead for their claims. Another fundamental condition was the accompaniment of national and international human rights organizations that throughout all this time worked to build the case. During the trial, we present more than 100 witnesses, more than 40 expert witnesses. We present military documents. We present videos, forensic evidence that have been collected throughout hundreds of exhumations and that constitute the physical evidence of the genocide. We have a very strong case. And I speak of international organizations, human rights organizations, because both converge, national and international organizations both converge to construct the case. For a moment, it was practically impossible in Guatemala to continue with the case, so we opted to submit it in Spain, which has jurisdiction due to universal jurisdiction. All the evidence that had been collected at the national level and the evidence that was in international sources such as archives was presented to the national audience in Spain. Arrest warrants against Grossman and other senior military commanders were achieved, but before, this was 10 years before we achieved the sentence in Guatemala, the Constitutional Court inside the country denied the extradition, arguing that they should be tried inside the country. Despite this setback, the international arrest warrants encouraged the case in the country. Another external influence that facilitated the conditions for the trial was the presence, as it has been said, the presence in Guatemala of the International Commission Against Impunity. This commission is also sponsored by the United Nations. And it's a very generous commission because it's like an international group of prosecutors inside the country that had to work with national prosecutors and had to present their cases in front of national courts. But even despite this commission was not ordered to investigate cases of human rights violations during the war, it was also a factor that helped the case to progress. As it has been said, one of the main obstacles in the country for the prosecution of this crime was the weakness and the dependence of the judiciary. as it has been said, you need not only the capacity but the will to prosecute these cases. And with the presence of the Commission in the country, there were new conditions for the appointment of independent officers in the Supreme Court and in the Public Minister. In fact, I was appointed as Attorney General after the moment of the process in which my predecessor was appointed. And I think that the presence of new officials, prosecutors, and independent judges was an indispensable requirement to be able to bring to trial the case of genocide. Regarding the second question, what is the legacy of the trial? It's something remain after the annulment of the sentence and of the trial. And I will say that without any doubt, the trial and the sentence have effects for the victims, for Guatemalan society, and for the strengthening of the rule of law in the country. For the victims, the trial has the opportunity of recovering a citizenship that had been snatched away. The denial for so many years for justice for these crimes, the possibility of having access to justice, have placed them in a situation of exclusion and constant victimization. And the trial gave them the opportunity to be on equal footing with those who had ordered the atrocities, to be able to say to them, to the perpetrators directly into their face, what you have done is not right. We are persons, we are not animals, we never deserve these crimes. When the sentence condemned the commission of the crime, it was a message for the Guatemalan society. On the one hand, it recognized that this serious crime had occurred, that they were wrong, and that they should never happen again. Regarding Guatemalan society, for many years, in Guatemala, there was a growing mistrust toward the justice system. And I believe that the conduct of the trial, the fact that it was public and that everybody could know what was being debated, the reasons that the court had to judge, that justice finally faced those who had held so much power in the country, all these factors contribute to the recovery of the confidence and to have a citizenship ready to defend it. Last year, in 2055, the citizens of Guatemala came out to the streets to demand justice for corruption cases. To me, there is a very strong link between the trial for genocide and these new citizens' demands. And with regard to the rule of law, and I will end with this, in despite of the fact that the prosecutors and judges had to face small campaigns and spurious criminal charges, judges and prosecutors in Guatemala recover a power that for many years they had not exercised. It was the same judge, Miguel Angel Galvez, who sent a trial to Grossman, who never asked them if the former president, Otto Perez Molina, will face a trial for corruption. The possibility that courageous and honest officials were able to exercise their positions with absolute adherence to the law transformed them. And and transform also the way in which citizens see them. Today in Guatemala, a country that traditionally has lack of heroes or heroines, the judges and the prosecutors are the ones who have received the social recognition. Of course, there is a lot of left to do in the country, and the trial itself is being carried out now behind closed doors. However, I am convinced that the progress was made, so these events will not happen again in Guatemala. Thank you.
Thank you very much, Claudia. We started 15 minutes late, but I think we're now 5 minutes past the schedule. Since we're in Claudio Grossman Hall, I did want to ask you one question, if I could, and that was the effect of the Inter-American Court judgments and what impact. That's one factor. We've dealt with many, many factors that can encourage externally these cases. But I remember the late Judge Barrientos talking about that. Just interested in what impact that played and how you see that as something that can contribute to justice and the rights of victims elsewhere.
Yes, the rulings of the Inter-American Court of Human Rights were very important and had a direct impact in the cases, not only the case of genocide, but all the cases in the country. This criminal chamber of the Supreme Court, led by Judge Cesar Barrientos, that is, expelled a ruling saying that this jurisdiction was obligatory inside the country, and that every obstacle, the fact or the jury that was impeding these cases to continue should be removed. And when they have this sentence of the National Supreme Court, all the judges inside the country start to repel the spurious incidents that were presented by the defendants, so the cases could go on.
For that response, I think, I know we probably have questions, but I know people need to get on to these panels, which were to begin at 10:20. But would you join me in a round of applause to our participants today and thank them for. And you'll see in the agenda where we've got, I think at the moment, 2 concurrent panels. I don't know if Matt or someone can tell people exactly where those places are, but it's necessary to move to those places as quickly as possible.